Okay, and welcome to the third video in our series looking at occupiers' liability as a special duty situation. And you'll recall from our first and second video that we looked at what's the difference between a lawful visitor and a trespasser, and then we looked at the Occupiers Liability Act of 1957, which deals with lawful visitors. The Occupiers Liability Act 84 deals with trespassers. I'm always going to start these videos off by leaving the tortious liability equation up. And the reason for that is to try to demonstrate to you that regardless of the special duty situation, your procedure for demonstrating tortious liability is always to show that a duty of care exists, then to demonstrate how and if that duty is breached, and then to look at the issue of damage. So is there causation? Has the defendant caused the injury or damage? And then is the defendant's actions not too remote from the damage that has been caused? And just to make sure that we're fully aware, occupiers liability, in fact any of the special duty situations, relate to the first two. They relate to duty of care and breach of duty. The special duty situation is occupiers liability, and therefore we need to look at the special circumstances that exist above and beyond the general tort of negligence. And the background to this is that a trespasser is not a lawful visitor. So let's just make sure that we've got that. So a trespasser equals not a lawful visitor. So therefore, if they are not a lawful visitor, they are excluded under the protection of the OLA 57. Which means that if somebody is a trespasser and they are damaged whilst on your property, that they are excluded from being cared for. There is a duty of care exclusion under the Occupiers Liability Act 57. Now I know that most of you are going to say, well, that's tough. Of course, there shouldn't be. There should be no duty of care for people who are not invited on that are trespassers. The problem is that we all know that in law that there are some circumstances and instances where that's not necessarily fair. And let's just take a think about it. Let's think about a wandering child, where a wandering child who manages to slip their parents' care drifts onto somebody's property or land and is injured. Now, there's no doctrine of allurement, there's no repeated visits, so that child's presence on your property cannot be seen to be lawful, therefore they are a trespasser. If they are injured whilst on your property, they have no ability to claim that a duty of care was owed. Some people have said that that's unfair. And the key case that looks at that is British Railways Board versus Harrington 1972. You may have recalled this if you have done statutory interpretation or judicial precedent in Unit 1 for AQA. And in this case, the claimant was a child, 6 years old, and was badly injured when they trespassed onto an electrified railway line owned by the defendants. The railway line ran next to a field open to the public, and where the defendant knew it was common for children to play. The fence between the field and the line had been trodden down for some time, but the defendant had done nothing about it. The House of Lords in this case held that the defendant was liable because common sense and common humanity suggested that if a company were to build something as dangerous as an electric railway line, and that was in the vicinity of an area in which children played, that they should take measures to protect the children, particularly where the danger was not obvious to a small child. However, this duty of common humanity was uncertain in its scope, which meant that Parliament had to clarify the position, and it did so through the enactment of the Occupiers Liability Act 1984. So, in essence, what the judges did in the House of Lords was that they changed the law somewhat. The child in this case was most definitely a trespasser. They should not have been there. But as the judges very clearly said, humanity would suggest that there is a requirement to make sure that the area is safe regardless. The child was a trespasser, and in British Railway Board versus Harrington, the judges created a duty of care to look after that trespasser. Now, this duty of common humanity was just not clear. So Parliament had to respond, and it responded by passing the Occupiers Liability Act 1984, which gave certain protection in certain circumstances. Okay, so let's have a look at when a duty might be owed. All right. So a claim under the OLA 1984 must overcome two preliminary hurdles. The first hurdle is that the claim must arise out of a dangerous state of the premises, not the dangerous activities of the claimant. So this is about your dangerous premises. Okay? If the premises are safe, so let's have a look. If premises are safe, okay, but the accident is caused by C's unwise actions, then no duty. So if your premises are safe, then there is no duty created. You have no liability to a trespasser. It's only when your premises are not safe that a liability might, and I say might, be incurred. And we'll look at how it might be incurred when we look at the second of the hurdles. Our key case to demonstrate this dangerous premise idea is Keown versus Coventry NHS Trust 2006. And in that case, an 11-year-old boy enters the grounds of a hospital. They're open to the public. And he began, as some children do, to climb the underside of a fire escape. The child fell from about 30 feet and suffered quite severe brain damage. It was accepted in court that he was a trespasser. He had gone beyond the scope of his implied permission. Remember, we go back to that first video lesson on how we imply that somebody is a trespasser. And one of those ways is to area, or you've got area, purpose, or time, if you remember. So he'd gone beyond the scope of his implied permission, and therefore he sued as a trespasser under the Occupiers Liability Act 1984. The Court of Appeal, reversing the trial judge, said that the fire escape could not be regarded as a danger due to the state of the premises. It was dangerous only because the claimant was misusing it. And in an obiter dicta, the judges said it would not be reasonable anyway to expect the NHS to offer protection against a danger such as this. Even if the fire escape could be regarded as an allurement, so remember the doctrine of allurement, safe premises do not become unsafe simply because they are attractive. So an occupier does not owe a duty under the OLA 84 when the risk is created by the dangerous activities rather than the state of the premises. So that's the first thing to get a grip of when you look at a problem question. Is this about the premise, or is it about the activities of the claimant? The second hurdle for us to jump is that the provisions of the Occupiers Liability Act 1984, Section 1, Subsection 3 must apply. And those provisions are threefold. The first is that the defendant must be aware of the danger or has reasonable grounds to believe that it exists. So he's got to know about it, or have grounds to know about it. The second is that he knows or has reasonable grounds to believe that someone else is in the vicinity of the danger or may come into the vicinity of the danger. So he's got to know about the danger, and he's got to know about people are likely to use that danger or come into contact with that danger. And the third stipulation is that the danger is one in which in all the circumstances he may reasonably be expected to offer some protection against. So should he offer protection? All of those three things have to apply. So the claimant must show that all three provisions exist. Okay? If not, the defendant owes no duty and the claim fails. So there are two hurdles, and the second hurdle has three very clear parts. The defendant has to know of the danger, he has to know that people are likely to use that danger, and he should reasonably protect against it. So you can start to see that from our original anger about protecting trespassers, there are some very, very strict rules which might prevent most cases there being a duty of care. And we're going to look at, just to identify this idea about all three provisions existing, we're going to look at two interesting cases. The first is Donahue versus Folkestone Properties in 2003. And in Donahue, a trespasser, the claimant, went swimming in a harbour late one evening in the middle of winter, and they were injured by an underwater obstacle. Allowing the defendant's appeal, Lord Phillips, Master of the Rolls, said that they owed the claimant no duty of care. They knew of the obstruction and may have known that he was in the habit of swimming in the harbour during the summer, but they had no reasonable grounds for knowing that he or anyone else would come into the vicinity of the danger late at night in midwinter. An occupier will not owe a duty under Section 1, subsection 3 of the Occupiers Liability Act if he cannot be expected to know that trespassers will be in the vicinity of danger at that time. So in this one, he knew of the danger, so that's a tick, but he did not know someone would use the harbour for swimming. Because it's late at night in the middle of winter, only a complete idiot would do such a thing. So there's no liability. So let's have a look then at Scott versus, it's actually Scott and, let me just write that in. I don't know why I've missed that, but it's Scott and Swanger versus Associated British Ports in 2000. And in two separate incidents, actually, two teenage boys were badly injured whilst train surfing, that idea where you get on top of trains, like this idiot here, although, of course, this railway is not moving, but nevertheless, there is a ridiculous risk-based game called train surfing. And two teenage boys were badly injured whilst train surfing on the defendant's premises, and they brought claims under the OLA 1984. The trial judge found as facts that the boys would not have been deterred by the provision of offence, and that they were fully aware of the risks that they were taking. The Court of Appeal agreed, since the absence of offence was not the cause of the claimant's injuries, their claim was bound to fail. So a court may decide that the defendant has the relevant knowledge because of previous incidents on the premises. So you have two cases here that demonstrate quite clearly that you need all three in order to have that liability. So let's have a look at the duty. Where have I got to find my thing now? Here we go. Let's have a look at the duty under the OLA 84 then. And the duty can be seen in twofold. The first is that the duty owed by an occupier to a trespasser is to take such care as is reasonable in all of the circumstances to see that the trespasser does not suffer injury on the premises because of the danger. That's exactly the same as the OLA 57 effectively, and it just sets up a statutory duty of care saying that you need to make sure that your premises are safe. If they are not safe, then there may be a chance that you could be liable if a trespasser injures themselves. Now, Section 1.2 says the terms occupier, trespasser and premises have the same meaning as in the 1957 Act. Well, you'll remember that the Act doesn't clearly define occupier and premises. What it does is it allows case law. It allows the case law that has existed before 1957 to define those factors for us. So, let's just have a look at discharging the duty then. How does a defendant discharge the duty? And courts take a reasonable and brisk approach when considering if an occupier has done enough, and they look at a number of factors. And some of these factors might be the likelihood of trespass, the serious nature of the injury, The cost and practicality of precautions. What is the likely age of the trespasser? What's the common sense? And the fact that an occupier should not have to guard against an irresponsible minority. And this last point here can be seen clearly in the case of Platt versus Liverpool City Council. And in that case, a child trespasser was killed and his friend was injured when the derelict house in which they were playing collapsed. It was accepted that Section 1.3 of the 84 Act was satisfied, but the Court of Appeal found no breach of the duty. So they agreed that all of the circumstances that we've been through already existed, and therefore a duty existed. But the court said that there was no breach of that duty. So there was a duty, yes, but there was no breach. And there was no breach because the defendant had discharged the duty. Unoccupied council houses had their doors and windows covered with metal sheets. I know these are wood, but you can see the point I'm trying to make. They were inspected once a day to ensure the sheeting had not been removed. In addition, the property in question was surrounded by a corrugated metal 2-2 gauge fence, which was 8 foot high, secured on a wooden frame and secured to wooden posts embedded in concrete. The corrugated metal sheeting was attached to the frame by 2-inch long nails, and those nails had a screw thread which could not be removed without special tools. Rejecting a suggestion that the council should have hired security guards, Lord Justice Kennedy said that it was simply absurd to argue that the council had failed to exercise reasonable care. He said that an occupier may have done all that is reasonable even if he cannot guard against a determined and irresponsible minority. Okay, so let's have a look at warning signs. As with the 57 Act, the defendant may discharge the duty, or an occupier may discharge the duty by putting warning signs or discouragements. Okay, and that's catered for in Section 1, subsection 5 of the OLA 1984. And the case that we use here is Tomlinson versus Congleton Borough Council. We've already done this case, if you remember, when we looked at what was the difference between a trespasser and a lawful visitor. And in Tomlinson, if you recall, the claimant visited a country park which was owned by the defendant council. He had chosen to dive into the lake despite the presence of a sign forbidding swimming. Now this doesn't necessarily, it says no bathing, no paddling, so this sign says exactly that. At the point he dived in, he became a trespasser. Do you remember? He becomes a trespasser as per purpose. He's not using the area where he is for the right purpose. And that was because he'd moved from activities he was permitted to undertake to an activity he was not permitted to undertake. When he was injured in the lake, his claim was brought under the OLA 84. Even though he had started as a lawful visitor, he became a trespasser. The court said that clear and visible signs warning of a danger may be all that an occupier needs to do to satisfy his duty under the Occupiers Liability Act 1984. And in this case, the claimant lost. So, as with the OLA 1957, the occupier may discharge the duty by warning signs or discouragements because of Section 1, subsection 5 of the OLA 84. What was interesting in this case is that even though the defendants made it known that they were going to turn the land into a marsh area to prevent accidents like this in the future, the judge said that that was unnecessary and too costly a precaution. They did not need to go to that length. The sign was sufficient to discharge their duty. So let's quickly have a look then at defences. 3 defences as per normal: contributory negligence, consent and excluding liability. Contributory negligence, the 84 Act makes no specific mention of contributory negligence. However, it is clear that judges will accept the defence, and when they do, it works in exactly the same way that it does for ordinary negligence, so we're not going to cover that again here. In terms of consent, there is a specific section 1, subsection 6, and that the defendant owes no duty in respect of risks willingly accepted by the trespasser. And the case that we're going to use here is Radcliffe versus McConnell, 1999. And in that case, the claimant is a 19-year-old student. He climbs over a locked gate late one night and dives into a swimming pool. The swimming pool was closed for the winter and was partially drained. This one's completely drained, but the one that he dived into was partially drained. And he apparently dived into the shallow end and hit his head on the bottom. This caused injuries which left him almost totally paralysed. He sued the college. He sued the defendants under the Occupiers Liability Act. The swimming pool belonged to the college. The trial judge found in the plaintiff's favour, subject to a visitor deduction for contributory negligence. So they found in favour of the claimant, but they took some of that claim away because of contributory negligence. However, on appeal, the defendant's appeal was allowed. Lord Justice Stuart Smith said that there were several warning notices around the pool, and the dangers of diving into water of an unknown depth were too well known to need any further express warning. The plaintiff had accepted the risks, and under Section 6 of the Act, his claim must fail. An occupier, therefore, owes no duty in respect of risks willingly accepted by the trespasser. So on appeal, this case was lost because of Section 1.6. And finally, we're going to look at excluding liability, if I can find it. I seem to have lost excluding liability. I know it's up here somewhere. There we go. In terms of excluding liability for the 84 Act, the law is not clear. It's not clear as to whether an enter at your own risk sign is going to be sufficient to exclude your liability. Now remember what we said about the difference between excluding liability and warning signs. Warning signs will say things like danger, don't swim here, danger of death, danger of electrocution. It tells you what the danger is. Exclusion of liability is when you say, if you injure yourself, it's not our fault. We take no responsibility for it. So there's a difference between the two signs. And in this case, the law's not clear if an enter at your own risk sign excludes your liability. There's no case law, and it's not expressly dealt with in either the OLA 84 or the Unfair Contract Terms Act 1977 as it applies to trespassers. You may be able to exclude, probably but with the same restrictions relating to business premises in the OLA 57 and the UCTA 77. And one of the reasons why that might be the case is you might want to consider the humanity element to the ruling in British Railways Board versus Harrington that we spoke about earlier. So finally, we'll look at remedies. And there's a slight difference here than there is for the OLA 1957. Successful claimants can claim for death or injury only. Section 1, subsection 8 of the Occupiers Liability Act 1984 excludes a claim for loss to property. So you can see right the way through the rules that have been set in place, but also in terms of the remedies and the defences to a certain extent, the courts and the law does not make it easy for somebody to bring a claim against an occupier if the claimant is a trespasser. Now, that's relatively quick, it's straightforward and it's easy. But what I want you to do is just to consider for a moment so as you are completely clear. When we talk about discharging the duty, just give me 2 seconds. I'm just going to make a quick change here. So, when we talk about discharging, let me draw a line down here. When we talk about the duty of care, in this instance, those are going to be the 2 hurdles that we looked at, in this case anyway, for the OLA 84. Okay, for the OLA 84. And they are going to be the the first hurdle in Keown about dangerous premises opposed to dangerous activity, and then they're going to be the 3 key stipulations in the OLA 84. That's identifying the duty of care. Once you've identified the duty of care, then what's going to happen is you're going to look at discharging the duty. And what we mean by discharging the duty is, has the reasonable man done enough to discharge, to make sure that he has fulfilled his duty? So the first half of this video looked at the duty of care. The second half looked at the breach of duty. When we talk about discharging a duty, we're talking about how you breach it or how you don't breach it. And this, if you remember, was the issue about Platt versus Liverpool City Council. Okay, so just so you are aware, duty of care, the 2 hurdles. Breach of the duty are things like warning notices and so on and so forth. All right, thank you very much indeed.